The 14th Amendment's Equal Protection Clause was added to the Constitution in 1868, but within 30 years, the Supreme Court had handed down a pair of decisions that reduced it to meaninglessness. Those two decisions were Plessy v. Ferguson and the civil rights cases. This video focuses on Plessy v. Ferguson. Despite the fact that the 14th Amendment forbids states from denying any person the equal protection of the laws, in 1890, the state of Louisiana passed a law that required white and non-white train passengers to sit in separate cars. An early civil rights organization comprised of both black and white members thought the law was clearly unconstitutional. They decided to challenge it, and they recruited a man named Homer Plessy to help them. Though he looked white, Plessy had one African-American grandmother and was therefore classified as colored. Plessy and his allies alerted authorities that Plessy would be attempting to illegally sit in a white train car on a particular date and time. When he attempted to do so, the police arrested him. He then brought his case to the United States Supreme Court. In 1896, in one of the most infamous Supreme Court rulings in American history, the court decided by a 7-1 vote that the Louisiana law was constitutional. The court reasoned that non-white customers were not being completely denied the right to ride the train. They were merely being required to use a different train car. The court adopted a doctrine that came to be known as separate but equal. Legally mandated segregation is permitted, as long as non-whites are not entirely denied a service or benefit. What about the Equal Protection Clause? On that point, the court said, the object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law, but, in the nature of things, it could not have been intended to abolish distinctions based upon color, or to enforce social, as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. The damage caused by this decision cannot be overstated. It launched the era of Jim Crow, in which black and white citizens were ruthlessly segregated in schools, bathrooms, theaters, and just about every other aspect of public life in many states across the country for decades. But Plessy is also remembered for making one of the worst, most deceitful arguments in Supreme Court history. The court majority argued that laws permitting, and even requiring, their separation in places where they are liable to be brought into contact, do not necessarily imply the inferiority of either race to the other. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction upon it. In other words, the court was saying that when whites passed laws segregating the races, they weren't implying that black people were inferior, and that if black people got that impression, it was their own fault and that they should just get over it. The court also said that Plessy was wrong to think that social prejudices may be overcome by legislation, and that equal rights cannot be secured to the Negro except by an enforced commingling of the two races. We cannot accept this proposition. If the two races are to meet upon terms of social equality, it must be the result of natural affinities, a mutual appreciation of each other's merits, and a voluntary consent of individuals. In other words, the court was saying that forcing white and non-white citizens to interact would do nothing to improve race relations. This is clearly false. Racial harmony can only occur when different groups have a chance to interact with each other and get to know each other. 7 members of the Supreme Court agreed with an opinion based on 2 obvious falsehoods. That segregating the races didn't imply that one was inferior to the other, and that integration cannot reduce prejudice. But one member of the court didn't agree. That was Justice John Marshall Harlan, and he wrote perhaps the greatest dissent in Supreme Court history. In his most memorable passage, Harlan wrote, "In view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man, and takes no account of his surroundings, or of his color, when his civil rights as guaranteed by the supreme law of the land are involved." Harlan's dissent then exposed the majority opinion for the fraud it was. He attacked the majority's argument that segregating the races doesn't imply that one race is inferior. He wrote, "It was said, Louisiana does not discriminate against either race, but prescribes a rule applicable alike to white and colored citizens. But this argument does not meet the difficulty. Everyone knows that the statute in question had its origin in the purpose, not so much to exclude white persons from railroad cars occupied by blacks, as to exclude colored people from coaches occupied by or assigned to white persons. The thing to accomplish was, under the guise of giving equal accommodation for whites and blacks, to compel the latter to keep to themselves while traveling in railroad passenger coaches. No one would be so wanting in candor as to assert the contrary." Harlan's opinion stands the test of time because it was so well written, but it also predicted the future. He predicted that the judgment this day rendered will, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. He was right. Today, Dred Scott and Plessy are considered two of the court's very worst decisions. Furthermore, he correctly predicted what a future of racial segregation would look like. While the majority insisted that segregation was the best way to achieve racial peace, Harlan disagreed, saying, "The destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted under the sanction of law. What can more certainly arouse race hate, what more certainly create and perpetuate a feeling of distrust between these races, than state enactments which, in fact, proceed on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? Laws regulating the enjoyment of civil rights upon the basis of race can have no other results than to render permanent peace impossible and to keep alive a conflict of races, the continuance of which must do harm to all concerned." But for all of his logic and passion, Harlan stood alone. The system of separate but equal stood for almost 60 years. But Plessy v. Ferguson was only one of two major Supreme Court decisions that severely limited the Equal Protection Clause. The other was called the Civil Rights Cases, and it's the subject of the next video.